Representative Sampson.
Thank you very much, Mr. Chairman. And thank you, Kevin, for being here. I'm down on this end over here.
Oh, up there. Sorry.
Sorry about that. It's a big room and we're kind of spread out. I sincerely appreciate you being here today. You're the person I would like most to talk about this issue of House Bill 6200, which I guess is going to be a hot topic today. I'll start by saying I'm very, very happy that we're having the conversation. I'm less happy about the existence of the bill, but the fact that we have you here and we're going to have a discussion about what reasonable suspicion is and kind of clarify for the citizens of Connecticut that it is perfectly lawful to open carry a firearm, I think is a good thing, and I think that's part of the source of this problem is that many people are not aware of that. And I think it's a good conversation to have, partly because there are many people like myself who are very, very strong advocates of the Second Amendment, and I believe very, very strongly in our constitutional principles, not just the Second Amendment, but also the civil liberty protections in the Fourth Amendment. But I'm also very, very pro-law enforcement, and I have some close friends who are police officers and have been faced with similar situations that have been the cause of this legislation coming before us. And we've been back and forth about what the best possible solution is. And I would like very much to work towards a solution that satisfies constitutional protections, but also the safety of police officers. I have concerns about whether or not this bill is it, and I'll ask you some questions that may shed some light on why. I guess the balance here that we're trying to strike is between the safety of a police officer and the civil liberty protections of the individual that might be open carrying a firearm. So I guess the question I have, and thanks to Representative Berger for bringing up his hypothetical, because in that case, as a layman, I would say there's absolutely reasonable suspicion if someone drops a firearm or unholsters a firearm. I think this question is really about someone who is, as you stated, doing absolutely nothing wrong, because it is perfectly lawful to carry a firearm in the state of Connecticut openly. So maybe you could do me a favor and just kind of describe for me what the bar is for determining reasonable suspicion in any case, whether it be to ask somebody for a pistol permit under the current law or even to pull over a car.
Well, the law calls it a reasonable articulable suspicion that depends on the facts and the circumstances of the case. Beyond that, it's pretty darn hard to set forth any. It's certainly not probable cause. It's a reasonable articulable suspicion that a crime has been committed or is about to be committed. The example, the Supreme Court, U.S. Supreme Court case that described the facts is when a police officer observed a man standing outside a store that was getting their closing hours, and he was acting in a manner that was suspicious because he was looking up. He appeared to be looking around to see if anybody's watching him, to see if there were any customers. He appeared to be casing the store with a plan to go in and rob it.
Right.
And it was several different circumstances that came together and reasonably led the police officer to suspect that this person was about to go in and rob the store. He approached the man and saw a bulgy something, patted him down, and found a gun. These are cases that have to be decided based on the facts and circumstances of the case. And articulable is important because it requires facts that not just I had a gut hunch that something was wrong, because I've been around before and I see this and I just felt in my gut it was wrong, but facts that the police officer can articulate and describe that leads to a reasonable suspicion. Beyond that, there's no legal standard. You have to look at each fact situation as it's presented. I
understand completely, and again, that's why we were here, because it's a difficult thing to nail down sometimes. So my understanding is that the requirement for reasonable suspicion to detain someone is federal law based on a Supreme Court decision. Is that correct?
Well, it's the United States Supreme Court, but our state would also, and I don't know if it's specifically held, I know our state Supreme Court has held that that particular amendment is interpreted the same as the federal Constitution. But it's a matter of constitutional law, certainly under the Fourth Amendment, which is a binding and applicable to the states.
Right, of course, and as you just stated, so the federal law and the Constitution would be the supreme law of the land.
Yes.
Yeah, and that's one of my concerns here. Is I keep saying about this particular bill, and when we had it last year, that I don't think passing it makes one bit of difference, and that is because the Constitution is still going to apply. And so are the civil protections of the citizens of the state of Connecticut on a federal level. So I can imagine that any of the scenarios that have been presented about when someone could be detained, the same arguments could be made in court about whether or not the officer had reasonable suspicion to detain someone. Yeah, I mean, you mentioned that it's a public policy issue in Connecticut. But I don't know that, while we can write a lot of statutes, in fact, we do write a lot of statutes that I think are in conflict with constitutional law. The matter that it's public policy, I guess, is it your feeling that we have the ability in the state to override what that constitutional protection is?
No, what I'm saying, no. If the Constitution, we don't have a right to override the United States Constitution. No, we don't in that area. What I'm saying is that requiring a permit holder to carry on his person the permit, that doesn't violate constitutional law.
No.
Neither does requiring the permit holder to show the permit if requested.
Right.
If the officer, and under the bill, is especially if the officer sees the firearm.
Right. Well, I guess that's the crux of it. There is that's your opinion. Is that
that's my opinion. It's
Right.
our smarter minds than mine. And
Right.
we have a group of appellate lawyers in our division who are terrific.
I understand.
My opinion might not be worth too much at this stage in my life. There's a lot of gravel up here.
You and me.
But there are very smart, wise lawyers around who feel very strongly this way.
You and me both, Kevin. I don't consider myself to be an expert either, which is why I am always willing to listen and try to hear all sides of every issue. And again, as I pointed out from the beginning, this to me is a genuine issue that needs a resolution. And that resolution could be a lot of different things. It could be better training of police officers to understand at what times and points they can actually detain someone to ask for their identification. It could be a modification of our existing laws about carrying firearms. It could be a lot of different things. I just worry that passing this law doesn't. You said a mere intrusion of asking for someone's permit does not violate the Fourth Amendment, but the Terry law that was mentioned earlier is exactly about the same thing for driving a car. You cannot just pull over someone for driving and asking for their identification. I think it's a very similar situation. You said that carrying a firearm is a perfectly lawful activity, and it's perfectly normal, etc. Is there any other perfectly lawful activity that anyone could be involved in where they lose their Fourth Amendment civil protections and can be detained by a police officer and ask for identification?
Well, sure. A person out fishing in a stream, and a conservation officer approaches him. Do you have your license? Show me your license.
Right.
I think they're required actually to wear their license on the outside of the clothing.
Right, and
if they don't have it, a conservation officer can certainly require that person to show the license.
Yeah, no, I know that example has been used over and over again, but there are a lot of distinctions, certainly, about the difference between what is a constitutionally protected right versus a permit to hunt, and the fact that it is required to be worn on the outside of one's clothing from the get-go. You're not required to carry your driver's license on the outside of your car, for instance.
No, you're not. I think the intrusion of stopping a car, for having somebody pull over by the side of the road and actually stopping them, is probably a greater intrusion than being in contact with a pedestrian saying, "Would you please show me your permit?" It's an intrusion, but it's a question of degree. And when the question was asked to me earlier, it was a matter of constitutional issue and balancing it.
Right.
And I think the limited nature of that intrusion, please show me your permit,
So
is such a limited intrusion that it certainly would pass constitutional muster.
in your opinion, forgive me for saying that. I'm not trying to be.
I agree.
I just want to point that out. That is only in your opinion.
Yeah.
So, another question. So, we both agree that the Fourth Amendment does exist and it is there for a purpose. Do you know what the purpose of the Fourth Amendment is and why it exists?
To protect people from unlawful search and seizures of their home or person or property.
Right. And do we know if? Well, I have several questions I'm trying to ask in a whole bunch of different ways. Can I just go back to the pulling over a car situation just for the sake of it? Can you? My understanding is that there are different degrees of necessity in the law before officers can act. Probable cause would be a significant requirement that you'd have to maybe show some evidence or proof of. Reasonable suspicion, in my understanding, is an extremely low bar. It's just anything that the officer can say. Let me ask you a question. So if would it be acceptable for a police officer to pull over a car because it matches the description of a car that was involved in a crime earlier that day?
I would think so, yes.
Understood. So just you were driving a silver sedan.
Depends on the situation. Now in the neighborhood, in the area, how many hours pass by, you need a little more on the facts.
Understood. Well, I mean, the point I'm trying to make is that I think that the notion that the reason why we would want to ask someone who is lawfully carrying a firearm for their pistol permit is because of a public safety issue. But I would say that it's an equal public safety issue for someone who might be driving without a driver's license. But we are prohibited in that particular case from doing so because of the Fourth Amendment. And you don't seem to disagree with that at all. So I'm just trying to really wrap my head around the understanding of why we are taking one lawful activity, and when we compare it with another lawful activity, this one would require someone to give up their Fourth Amendment protections to be detained, and another one would not. And that's the question I really would like someone to answer for me.
I think it might be better to compare it with other regulated businesses or regulated activities. The state, if it has authority to regulate certain businesses or certain activity, whether it's manufacturing, whether it's a business that presents health and safety issues to either the public or the people inside a building or the occupants or the workers, the law gives the state the right to make certain inspections of those businesses. And those inspections can be far more intrusive than just asking the operator of the business to see the permit.
Well, that's an exchange.
And the law permits that without warrant. And this isn't, as a matter of constitutional law, this certainly is a lot more balanced and reasonable or less intrusive than other inspections that are permitted without warrants.
Well, respectfully, Kevin, you're exchanging something if you own a business with the state. Your constitutional protections are your constitutional protections. Those are natural rights that the founders saw fit to say that the government has no business interfering with, which is why someone cannot go into your house for no reason either. And they need far more than just reasonable suspicion to enter your home and search it. Is that correct?
To enter your home, most of the time. Pose that question again, please.
Well, I mean, you were making the point that certain businesses, the government has the authority to inspect.
Yes.
Right. And again, I mean, that's, someone is conducting business with the public, and they have applied for the permission of the state to conduct that business. And I guess that's the crux of this question, is that you don't need permission of the state to lawfully carry a firearm. The fact is that
You do, though.
well, you are the state is allowed to regulate it in that they can determine whether or not someone is lawfully acceptable, but you cannot deny someone that is. Whereas the state can determine, what businesses are acceptable.
The state has the authority and does properly provide that if a person wants to carry a pistol or revolver, they're required to have a permit. And they're required to have that permit on their person when they're carrying it.
Yeah, that is true in
that's-
this state, but not every state.
Activity, well, every state, the United States Constitution gives the states the authority to do that. This state has done it, and so have some other states, not every state.
So, Kevin, are you aware of any circumstances where someone was questioned by a police officer to present their permit for open carrying, and they declined it and went on to commit a crime? Any one example?
I don't know. I don't know. Nope.
Okay. That's all my questions. Thank you, Mr. Chairman.
Thank you.